Business Organizations, Insolvency. Creditor Rights, Chapter 7 and Chapter 11 Reorganizations. Where debtors faced prisons and severe punishment in other countries in the past, the framers of the U.S. Constitution made provision to provide a process of rehabilitation for debtors, and took bankruptcy out of the jurisdiction of the states. Article 1, Section 8 of the U.S. Constitution states that Congress shall have the power to establish uniform laws on the subject of bankruptcy throughout the United States. The subsequent Federal Bankruptcy Code is broken into some famous chapters, including Chapter 7 addressing liquidation, Chapter 11 for the reorganization of a business, and Chapter 13 for the reorganization of an individual's financial affairs. The two most common measures of insolvency are cash flow insolvency, sometimes referred to as equitable insolvency, and balance sheet insolvency. Cash flow insolvency is reached when an individual or company is unable to pay its debts as they become due. Balance sheet insolvency measures assets against liabilities. A company or individual with liabilities exceeding assets is insolvent under this approach. Insolvency usually harms creditors whose debts go unpaid. The courts have often been asked to consider whether the board of directors and management of a corporation owe a duty to protect the interests of creditors as well as to their shareholders. The prevailing view in the US today is that the fiduciary duties of the board and officers are refocused when the company enters the vicinity of insolvency. It's not necessary for the company to have reached the point that its assets outweigh its liabilities, or its liabilities outweigh its assets, or reach the stage where it's unable to pay its debts as they become due. But somewhere in the general vicinity, the duties to creditors attach. The vicinity of insolvency is not yet clearly defined by the courts, but directors are expected to know when insolvency is nearby, and they're required to then start to consider the interests of a broader group of stakeholders that now includes the creditors. Chapter 11 is a reorganization maneuver available to individuals, corporations, and other business organizations. Individuals with debts under a certain threshold usually file for protection under Chapter 13. A company can file Chapter 11 protection when it becomes insolvent, unable to pay its debts as they become due. This provides the company with an automatic stay, forcing all creditors to cease their collection attempts. The idea behind Chapter 11 is to keep the business as a going concern, as opposed to shutting down and liquidating under Chapter 7. Although the company exists, a stigma is often attached to a company in Chapter 11, and publicly traded shares are often delisted from major stock markets. As debtor in possession, management continues to operate the business and acts as a fiduciary for the creditors. A key feature of a Chapter 11 is the plan of reorganization. The plan usually prescribes the sale of assets and restructuring of debt to help the company survive its cash crisis. Creditors then vote whether to approve the plan. If one or more creditors disagrees, the court has the power to cram it down, force the plan upon the dissenting creditors, as long as it meets the statutory requirements and is fair and equitable to all classes of claims. Disgruntled creditors can request the court to displace management as debtor in possession and appoint a trustee to manage the business. It is, however, unusual for the court to replace management with a trustee, and only takes place in cases of wrongdoing or some form of gross mismanagement. Creditors unhappy with the plan can also request the court to shut the company down and liquidate all the assets under Chapter 7 of the Bankruptcy Code. Chapter 7 is a bankruptcy liquidation proceeding available to individuals as well as corporations and other business organizations. Once Chapter 7 filings have been made, creditors have to cease their collection efforts under the automatic stay. There's a meeting where creditors are able to ask questions of the debtor. A trustee is appointed by the court, Assets are sold to the highest bidders. Stakeholders in the company stand in line when the proceeds of the liquidation are shared out. Common stockholders stand in line behind preferred stockholders, who stand in line behind unsecured creditors, behind secured creditors. Under the absolute priority rule, shareholders receive nothing until after the creditors have been paid in full. There is an exception to the absolute priority rule if the shareholder invests new value. A shareholder investing to benefit the company and other creditors, usually in a Chapter 11 reorganization rather than a Chapter 7 liquidation, will buy the right to jump ahead in the line. Chapter 7 offers a bankruptcy discharge for individuals, but not for companies. The debts of a company remain until the statute of limitations has run.